whenever you're ready.
When I heard of this news, the first thought that came to my mind was another bullying case, as I had previously heard of another bullying case about over a month ago before learning about this case. However, this case of bullying leads to a criminal act, appeared quite interesting to encounter. I'm Feli, and today I will be talking about a case which happened quite recently in an educational environment, but also begs the psychology field for it. This is the bombing case of SMAN 72, which happened this November. As a psychology student, I am aware of the pressures the education world might present to a student. Some of these pressures include bullying, which unfortunately still is a prevalent topic among school environments. The irony of these cases, occurring in a community meant to encourage learning and growth, stays a reminder of the imperfections of systems made to protect children and citizens in general, and I believe that to be worth discussing. In this speech, it is worth discussing what the case is about, direct intervention of the perpetrator, as well as addressing the Indonesia's imperfect legal systems and efforts to improve them. Now first, what is the case about? Before sharing my perspective, I will first lay out the context of the case. According to CNBC News, it was Friday, 7th of November at around 12:15, and at that time, a servant was delivered for a Friday prayer in a school area when suddenly the sound of at least 2 explosives could be heard and seen by those who are fortunate enough to not be too close to where the impact area was. Meanwhile, the unfortunate ones who had to experience a truly horrifying situation that leaves them with wounds both physically and mentally. There were fortunately no lives lost in this tragedy. However, there were a number of at least 54 people, 11 of which are students. However, newly updated data recorded 96 people, a much higher number of victims than what was found the day of the incident. Then the perpetrator was caught. He was 17 years old, an age where pursuing education should be one of his main focuses instead of causing harm in an environment meant for that. It was then discovered he had been the victim of bullying done by his peers in that school. But there were also other grim details. A student witness claimed he tends to keep to himself most times and would spend most of his time creating depictions of violence in his art. The witness even hypothesized the perpetrator's aim to take revenge and his life with it. From this established context, we get the sense that the perpetrator is most likely not in a well psychological state. However, there is also the subject of justice involved. Just because the perpetrator is a victim of bullying or suffering a potential mental health issue doesn't exempt him from accountability. Therefore, the question rises, what should he face between psychological treatment and legal trial? Psychological intervention, I would say that is a trick question. It was never about either this or that, but rather the hybrid of the first and next steps. Legal consequences are one thing, but this is a case that requires more than a sentence to prison, but further psychological intervention. As neuroscientist J. Geed discovered in his study, the frontal lobe does not develop until the age of 25. Therefore, the perpetrator's actions may reflect a lack of maturity in his thought process. Liputan 6 notes multiple voices speaking up about the perpetrator's experiences in school, highlighting that he was relentlessly bullied and mistreated by his peers. He did not make many friends, and often lead a relatively lonely lifestyle. And investigating deeper into his past, it was found that he is a child of separated parents, living with his father while his mother left the family to work as a state worker. This dysfunctional family dynamic is thought to have been a major motivator in his acts, as it was speculated to be his only known way of coping with the loneliness he might have felt. This situation calls for not only justice and consequences, but also a comfortable space for personal development. As such, rehabilitation would be highly recommendable for the perpetrator to follow through first, because through rehabilitation, the perpetrator is given a space where he can express his feelings and be provided the company he needed. As according to a study done by Lipsy in 2009, cognitive behavioral therapy, one of the therapies that can be given in rehabilitation, can reduce recidivism among youth offenders by around 20 to 30%. And this means that therapy can be expected to minimize the likelihood of engaging in further violent acts. And moving on, this case, although this case centers on the victim, the perpetrator, it is also worth pointing out the subtle presence of legal systems of Indonesia in catalyzing this case. Firstly, this case reflects the flaw in it. As criminologists like Reza Indragiri Amriel argues that this case reveals the lack of early intervention that the child protection systems in Indonesia takes when responding to cases like bullying. As the case was not addressed nor even intervened before it leads to violence, this implies a systemic failure in detection and support for vulnerable children. And therefore, I would like to propose for child and juvenile systems institutes to strengthen their protection of young individuals. On the other hand, the justice systems also requires improvement in terms of its legal consequences. I suggest laws protecting against serious crimes like this event need to be enforced with visible execution of proper and just punishment. Additionally, I believe school systems should also reflect intervention of bullying and enforcement of consequences in their students. Therefore, schools should approach it as a more serious case by providing a safer, more comfortable space for everyone for their students to request aid from educational institutes while emphasizing accountability and penalty for those engaging in oppressive behavior. To conclude my speech, this case is a reflection of various dimensions relating to child development as well as the implementation of justice systems in our country. Therefore, I would just like to remind us that justice is not just about it's not just something that is one-dimensional. However, but it is a multi-dimensional process requiring many studies of contextual cases, and therefore it requires a deeper, further investigation in order to deliver a just and optimum outcome for all parties involved in the case. That's all for my speech. Thank you so much.